This lawsuit, besides having 55 sheriffs and a retired police officer as plaintiffs, has more than 20 additional plaintiffs who represent some of what the best of Colorado is and has always been. Other plaintiffs include the Colorado Farm Bureau, Colorado Youth Outdoors, an organization that encourages and helps young people participate in the outdoor sports, and including the shooting sports. The Colorado Outfitters Association, the trade association for Colorado's hunting guides, who have been very seriously harmed by these poorly written bills. Two disabled individuals, and the organization Outdoor Buddies, which is a nonprofit that helps disabled people participate in the outdoor sports. And importantly, the case involves constitutional claims under the Second Amendment and the 14th Amendment to the United States Constitution, and it also includes claims under the Americans with Disabilities Act, because the ban on magazines holding more than 15 rounds is especially harmful to disabled people who may not have the mobility to be able to retreat to change a magazine when they're under attack, or may have only one arm, or difficulties with their fingers for any number of reasons. And so they especially, as our expert reports have explained, they especially need standard capacity, full capacity magazines for lawful self-defense. We've made tremendous progress in this case already. In June, we filed a motion for a preliminary injunction, and the result of all the preliminary injunction briefing back and forth was on July 10th, we got everything we had been seeking to fix with that preliminary injunction motion. The magazine ban not only outlaws magazines that actually do hold more than 15 rounds, it also outlaws every magazine which is, quote, designed to be readily converted to hold more than 15 rounds. And nobody knows really what that means, but the only thing it really could mean, if it means anything at all, is that essentially every detachable box magazine is banned. Because whether it's a 8-round magazine for your Colt pistol from the 1911 model from 100 years ago, or it's a 10-round magazine or a 13-round magazine, almost all of them today have a removable base plate so that you can disassemble it, clean it, or replace a worn-out spring. And because they have the removable base plate, every magazine could have an extender added to it, at least in theory, and there in fact are lots of aftermarket extenders. So the effect of this was to outlaw all magazines holding of whatever size. We sought the preliminary injunction on that, and as we pushed and pushed and pushed, the Attorney General, representing the governor in this case, because that's how in Colorado you sue against a state statute, as you name the governor as the defendant, ultimately conceded our point, and on July 10th issued new technical guidance which replaced the Attorney General's technical guidance for May, and said, well, you have to interpret design to be readily converted, in essence, to mean it doesn't apply to anything at all unless it actually has been converted, which is not really what the language says, but we'll take that temporary interpretation, at least for the time being, to protect people who have magazines of 15 or less. In addition, the magazine ban had a grandfathering clause, which said you can continue to own a normal magazine of 20 or 30 rounds for your rifle if you actually owned it on July 1st, and that's something everybody can understand. But it also said you have to maintain continuous possession. Well, what did that mean? Well, the Attorney General issued technical guidance in May, and it said continuous possession would end. You can maybe, when a friend comes over and you show him your magazine and you're right there in the room with him, he can hold the magazine in his hands for a few minutes, that's okay. But it said anything other than that would terminate continuous possession and thereby make your magazine illegal. So what that meant is if your magazine were broken and you took it to a gunsmith for repair, and even in Colorado, gunsmiths don't do on-the-spot service. That's an important distinction between Burger Kings and gunsmiths, is you usually leave the magazine for a couple of weeks or a few days at least with the gunsmith for repairs. And that meant that, well, continuous possession would be broken, and therefore you and the gunsmith would both be criminals. By pushing for the preliminary injunction, we ended up with the Attorney General writing entirely new technical guidance, which abandoned what they just said in May, and now said continuous possession is never broken as long as the owner keeps the ownership rights. Which means if you want to leave your gun with your magazine with somebody for half a year, because maybe you're going out of the country and you want to leave it with them for safekeeping so it doesn't get stolen, that's now been re-legalized in Colorado. But there's still a lot more to do on this case as we get to the core issues. The sponsors of the magazine ban repeatedly said that the only reason a person would own a magazine of more than 15 rounds is to murder a lot of people quickly. Well, that's a horrible group libel against literally millions of law-abiding citizens and against Colorado law enforcement. The Supreme Court has said in the Heller case that what you can't ban, the arms that are clearly protected by the Second Amendment, are those which are typically possessed by law-abiding citizens for lawful purposes. In our case, we don't get into the theory of a 100-round magazine or something like that, these things that don't really work very well and are rarely owned by people except as a novelty item. What we say is clearly unconstitutional is those magazines which are indisputably typically owned by law-abiding citizens for lawful purposes, which for handguns is magazines up to 20, and for rifles is magazines up to 30. But that's all we bring up in this case, because that's enough to say that a ban on 15 is unconstitutional, categorically unconstitutional, under the Supreme Court's precedent in District of Columbia versus Heller. One of what you can, just by observation, the people you know all around, you talk to gun owners, lots and lots of them own these standard capacity magazines. And not because they want to kill a lot of people at once, because they own them for good purposes of lawful self-defense and legitimate recreational shooting. They're also very commonly possessed by sheriffs and their deputies as carry handguns, a Glock or a Springfield or a Smith & Wesson pistol that might have a 16 or a 19-round magazine. And in the patrol cars today of almost every law enforcement organization, you will find an AR-15 type rifle with several 20 or 30-round magazines. And those sheriff's deputies aren't carrying those arms because they're going hunting, or because they're gun collectors, or because they want to kill a lot of people quickly. They're carrying them for one purpose only, which is the lawful protection of self and others. And the reason they choose those firearms so often with those magazines is because they believe those are the best choice under their particular circumstances. What kind of firearm fits their hand best, what they can control the recoil on, what helps improve public safety. And they believe that citizens have exactly the same right to choose those exact same firearms. This is the opposite of the idea that law enforcement is some kind of Praetorian guard that is superior to the citizens. Rather, the belief of the sheriffs is that they are elected by the people and given delegated power to serve the people and not to be their superiors who control them from above and have access to arms that ordinary citizens do not. These magazine bans also directly harm law enforcement. Nominally, there's an exemption in the magazine ban for people who work for law enforcement agencies. But not everybody who comes to the aid of law enforcement is a full-time employee of law enforcement. Let me just tell you one anecdote about the difference, the harmful difference that House Bill 1224, the magazine ban, would have made had it been in effect 20 years ago. In 1994, in Hinsdale County, in the southwest of Colorado, very rugged area, the sheriff knew he had to go out and do a high-risk road stop. And so he brought along a trusted person he knew, who he had actually trained to be a safe and proficient shooter in support of law enforcement. But this person he brought, who was a retired Air Force officer, was not a certified law enforcement officer. He was not sworn. He was just a good citizen helping the sheriff out. Well, the sheriff and the citizen went out on that traffic stop on the highway, and there the sheriff was murdered by the man and the woman in that car. The citizen was carrying his Beretta handgun with a 17-round magazine, and he fired all 17-round magazines as the murderers attempted to escape, and one of those rounds hit the tire of the escape vehicle and stopped it. And so then the murderers ran off on foot into the foothills. Over the next month, 200 law enforcement officers from all over came to participate in the manhunt for those people, and so did 100 other citizens, ordinary citizens, performing their role as the posse comitatus, coming to the aid of the sheriff voluntarily, bringing their own firearms of the type they happened to own at the time. And that they participated in the manhunt, searching buildings and remote areas all over, until 1 month later, finally the murderers were found in a remote cabin where they had committed suicide. If House Bill 1224 had been in effect 20 years ago, that good citizen wouldn't have had a 17-round magazine, he would have had a 15-round magazine, and the murderers would have escaped. House Bill 1224 is a deadly danger to law enforcement and to all of the public in Colorado. This lawsuit is not one of these bumper sticker things which says, what part of shall not be infringed don't you understand? It's not something that contends that all gun controls are unconstitutional. Regarding the background check bill that was passed by the legislature, which we are suing and saying is unconstitutional, we don't take a position one way or the other about the constitutionality of background checks on the private sale of firearms. But what we say is certainly if that could be constitutional, then you at least have to have a functioning system for that to happen. And House Bill 1229 is a dysfunctional order that people do these background checks without them in a practical way being able to do so. They have to bring the guns. If a neighbor on a ranch wants to sell a firearm to his neighbor on the ranch next door, they both have to go to wherever they can find a federal firearms licensee, a firearms retailer, who will perform that transaction. But that licensee is only allowed to charge $10 for filling out pages of paperwork, for incurring serious legal liability for any mistake on that paperwork, for waiting what is sometimes the hours or days it takes the Colorado Bureau of Investigation to complete what is supposed to be the instant background check. So few, if any, firearms dealers are going to be willing to do this. And that means in practice, the citizens who want to comply with the law won't be able to do so because there's no way to do the transfer without going through to the federal firearms retailer. Much even worse, and clearly unconstitutional, is that the bill, not only a background check bill, not only applies to the actual sale of firearms, but it applies to the ordinary use of firearms, which includes loaning firearms to someone else on a temporary basis. That's what people in real life in the United States and America, how they actually use firearms. And of course, these bills weren't written by people who have any respect for or knowledge of the way that real Americans use real firearms. So what this means is, let's say you have a friend from Kansas who's coming to visit. He's got an elk tag, so he's going to go elk hunting for a week. He comes and he's spending the night with you, and then he realizes, oh, there's a malfunction in his rifle. So he can't use it, and of course taking it to the gunsmith. Again, they don't do as-you-wait service. It'd take a while to get his rifle fixed. So you lend him your hunting rifle, and he goes off for 5 days, off to the hunting camp, hunts for elk, comes back, and returns the rifle to you. Well, under Colorado law, the new background check bill, both of you are criminals subject to up to 18 months in jail, and you lose your right to possess any firearm for a year. That's not rational, and it's not reasonable. Let me give you another example of this, and again on the harm to law, the direct harm to law enforcement. It's common in law enforcement for sheriff's deputies or police officers that their duty handgun, and sometimes the rifle they have in the car, the shotgun, is something that they buy out with their own money from an approved list of suitable firearms created by the chief law enforcement officer. But it is also true that most law enforcement offices have armories where they do supply firearms to deputies. So if you're a sheriff and you have a supply of AR-15s in a safe in your office, and you have a deputy who's been promoted from working as a jail deputy, now he's going to become a patrol deputy, you hand him the keys to a patrol car and say, here's your car. When you live in the county, so when you're off duty, just take the car home and you'll have it to be ready to respond in case there's an emergency where we need you right away. And here's an AR-15 rifle with 30-round magazines for you to keep in that car as well, because you may need a rifle for all kinds of different possible situations that could develop. And we expect you to keep the rifle in the car, and then of course when you're off duty and you've got the car parked at home, you secure the rifle and you take it inside. Well, the magazine ban does have a law enforcement exemption. So the author of this bill, the magazine ban and background check bill, were both written by Representative Rhonda Fields. So she knew how to put a law enforcement exemption into the magazine ban, and it's there. But there is no law enforcement exemption in the background check bill. So that means when the sheriff gives the AR-15 to the deputy and says, you're going to have this rifle for the next 6 months, according to House Bill 1229, they're supposed to both go down to the local gun store and ask for a background check on the deputy, and the deputy the gun store has to register that firearm in its own inventory books as if it were selling it out of its own inventory. And so the bill has in essence criminalized the ordinary operations of how law enforcement works, and the same thing with returning a stolen firearm to its owner. That's not a bill that is a thoughtful, sensible, common sense, reasonable gun control law. It's just the opposite. It's an unreasonable bill that was jammed through the legislature in 41 days without the careful consideration that the sheriffs had asked for. And back in January, they'd said, let's have some study committees over the summer. Let's think about it. Whatever we're going to do, let's do it right and do it thoughtfully. And instead, just the opposite happened. And now law enforcement throughout this state has been criminalized by the recklessness of the language in these bills. So what the sheriffs are standing for in this case is in some ways the genius of the American political system, where we have divided the power between the federal and the state and the local levels, and whenever any one part of that system becomes oppressive, the people, who are the ultimate sovereigns, can appeal to the other levels. And so here is our sheriffs, locally elected, appealing to our national constitutional rights, guaranteed by the Second and the 14th Amendments, to protect us from unreasoned, dangerous oppression enacted at the state level. Their belief, as you've heard, is that law enforcement and law and order are very important. And if you really believe in that, then you have to believe that the first priority of everyone has to be obeying the supreme law, the Constitution of the United States of America. And so what the sheriffs really are doing here is they are standing up for public safety and the rule of law, and we hope you will stand with them. Thank you.